International law is the way that states talk to each other, and it's the rules that they are meant to apply and uphold. And so if certain states are not doing that, what options do small states have? It's not like they can go around throwing their political weight around. They can't use military force or anything else like that. So law is the tool that they have access to.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi, Steph.
Hi, Janet.
So, let's say, calculating by the numbers of hours that you spend in touch with it, or sitting in its press room, or the numbers of cases it's gotten, or the numbers of decisions that it's making, which would you say is the busiest court in The Hague?
Well, I must confess these metrics are a little different in those cases. The numbers of hours I spent on it are probably ICC, but actual presence and the number of cases and the number of time spent in the court press room is absolutely the ICJ, the International Court of Justice, or the Cour Internationale de la Justice.
Well, I thought so. I've always found this rather a difficult institution to report on because the vocabulary is somewhat arcane, maybe a bit more technical even than some of the other courts with the memorials and counter memorials. But I do know I need to get a better handle on it because it's such a busy court.
Well, I can enlighten you in some bits, but of course we have a lot better person to round up and give us all the insight we need, which is Juliette McIntyre, a senior lecturer in law at the University of South Australia, the original hashtag Procedure Goblin on the International Court of Justice. Hi, Juliette.
Hello, nice to see you again.
And it's really nice to see Juliette, especially after 5 hours in the hairdresser's stall with her absolutely stunning bi-coloured hair, which is, I think, is even better than your pink mob, Steph. I'm really enjoying
If you call it a pink mob, then obviously the bi-coloured hairdo in 5 hours in the salon is going to sound better, but it looks great, Julia.
Thank you. Now, I love your hair though. It's so bright and fun.
So do I. I didn't mean to be quite so rude about it, Steph. I really do like it. I love the pinkness of it. I mean, mine's just boring. Let's be clear about that. So what I thought I'd start off with is what was a bit of a flurry of activity last month. It was the middle of September and there was an application by Mali about a dispute with Algeria over drones, and I'm sure we'll Stephopedia exactly that. But what was curious for me was that I got a message from a Malian contact who asked me about it. I mean, I'm really not used to people asking me about what stuff's going on at the International Court of Justice. And I had no idea how he had got to hear about this behind the scenes, sort of well before anything was made public. So I just wanted to ask you to start with, Steph, how does this stuff sort of emerge in your world? What do you know about and when do you know it? Are you allowed to tell us anything?
Yeah, no, actually we knew about it way before kind of the 16th of September, because I think it was very much early in the month, the 4th of December, that the Malian transitional government put out a very fancy press release saying that they were going to take Algeria to the World Court. And so I got calls about it from my colleagues, and because there was a whole story and a kerfuffle that we missed in sub-Saharan Africa or Saharan Africa, where there was a drone on the Mali side that was shot down by the Algerian army, and that Mali and Algeria were up in arms about. And then they had some diplomatic skirmishes about it. And then at some point, this press release came that they said they had brought it to the court. And of course, the first thing I do when anybody announces that they bring a case to the court is call the court to make sure that that application was made. And they said, no, if we get a formal application, you will get a press release. Now, that to me kind of shows two things. It shows that maybe they've gotten something, but it's not a formal application. And so they're not going to put out a press release. At least that was the impression I got, that whatever was sent was not the way that you should send it to the court, that they could do something with it. And then in the end, we did get an announcement that they had formally applied to file a case. But as I was also telling my Mali correspondent, the problem is that neither Mali or Algeria have accepted the jurisdiction of the court in disputes between states, so they both have to agree. And so if Algeria doesn't want the ICJ to look at it, it doesn't need to.
So over to you, Juliette. Why? Why is Mali bothering to do this?
Yeah, so it's so interesting. So this kind of jurisdiction is called forum prorogatum. And I'm going to just tell you guys like a little background history story of how this sort of came about. So obviously, both states need to consent to the jurisdiction, as you have correctly pointed out. And so this can either be in advance. So a lot of people have probably heard about things like compromissory clauses in treaties, the Genocide Convention being the famous one, where if two states are parties to that treaty and they're having a dispute about it, then the treaty itself gives the court jurisdiction. Or states can do something where they file a declaration with the court ahead of time and they say, yep, we're cool for jurisdiction over these kinds of disputes or in general. And then there's another way, which is via special agreement. So two states can come up with a treaty to agree to resolve a particular dispute. So it's kind of like an old-fashioned arbitral mechanism where you would set up your tribunal to resolve a particular dispute. You'd set out the rules about how things were going to be managed and so on. So this mechanism has been retained under the current rules of court. So even if two states don't have any other underlying treaties or other jurisdictional consent mechanisms, they can sign an agreement where they ad hoc agree to go to the court for one particular issue. So you might sometimes see this for border disputes, for example. So what's happened here and how this fits in is that Mali's basically asking Algeria to enter into a kind of special agreement. But instead of having a negotiation ahead of time where they set out all of the clauses, they've basically gone straight to the court and said, well, look, here's our application, here's our case, and we're inviting Algeria to agree to pursue this case as a respondent at the ICJ. Now, I said I'd tell a little bit of history, and I'm going to. Back in like the 1940s and 50s, it wasn't really clear how this worked. And in some cases, what the court actually did was say, well, we're going to infer that the states have consented to jurisdiction based on the fact that, yeah, they didn't really complain about it. They proceeded to argue the case on the merits. This happened in the Hague de la Torre case. So they said, look, you argued it on the merits, so we're just going to assume that jurisdiction's not a problem, even though there's no obvious basis of jurisdiction necessarily. And this happened in a few cases. And what would occur is that either the court, sometimes a little bit sketchy, I've got to be honest with you, would infer jurisdiction on the basis of state conduct, where they're like, look, if you don't complain about jurisdiction, we're going to assume you're okay with it. There were several cases, other states kind of picked up on this and they went, right, cool, we're going to file applications. Didn't know we could do this. Right, let's just file a bunch of applications. These cases got entered into the general list. They were given file numbers, everything kicked off. But then the respondent state just did nothing. They didn't consent to the case going any further. They didn't reply, and they certainly didn't argue it on the merits. So we ended up with like 10 or so ghost cases just floating around on the court's list where nothing ever happened. And then we get to the 1970s and the court changes its rules. It has a whole rule overhaul, basically. And one of the changes that it made was it brought in this much more formal, what we call forum prorogatum jurisdiction, where they now say, look, you can still file an application like this and invite the respondent to agree to pursue the case, but we are not going to put it in the general list. We are not going to give it an official file number. This case doesn't really actually exist until that consent has been manifested in a more formal way. So what's happened here is they've issued this press release kind of just to let us know that this is going on, I suppose. But nothing else is going to happen, and potentially nothing will ever happen. If you look at the court website, this case does not exist on the list of pending cases.
Yeah, and in the press release, they made a really big deal of it not being inscribed in the case list. And I was like, okay, sure. But now with this background, I actually understand why. Apart from why they could technically file this, I feel that this also kind of shows this change that we see in states where they tend to announce that they're taking things to the World Court also for the local audience. And I wonder if you think that that is what's happening here, because we saw some similar cases as well.
Yeah, definitely. So I think there's a couple of things going on here. The court is, I think, increasingly being viewed as a forum for political theatre, political maneuvering. It's not that the underlying case is completely invalid. That's not what I'm suggesting here. It's that what states, I think, have realized is that by saying we're going to pursue a case at the ICJ and taking some steps in that direction, they can score major political points. They can either put pressure on the respondent state to comply with things that they might want to comply with, or they can just gain, votes at home. Like, yes, we're taking this seriously. We're taking action. We're doing something. And I think it trades slightly on people not understanding how the court works, right? Like, I do think there's a certain cynicism here where you're seen to be taking action because you're filing a case, and then nothing's going to happen for years and years and years, and everyone forgets about it. The news cycle moves on, right? So it's a way of gaining a kind of short-term political boost. And so this is a slightly unusual way of doing it. I mean, I've seen other states talk about bringing a case. I think Cambodia and Thailand were talking about bringing a case again as well. Another one that was in the news media. This does happen. Well, sometimes you guys would be familiar with this. You see the press release come out. I think the French one did this. It was like a press release. There was a bit of talk about it, and then the case gets filed and it goes ahead. But a lot of the time, there will be a basis of jurisdiction. So the case gets entered in the list, and then the states have to either argue about jurisdiction or just proceed to the merits. This one's unusual because, as you said, there's no basis of jurisdiction for either of these states. It's unlikely, I think, that Algeria is going to agree to pursue this case. And so they weren't probably going to agree to a special agreement, to one of these treaties where you're like, yep, we're going to take our dispute to the court. That was never going to happen. So Mali's probably, I don't know, and anyone who works for the Malian government can correct me if I'm wrong, but they're probably like, look, let's just do this anyway. We'll score some political points. We'll bring attention to the issue because, of course, now this has been reported globally. People probably didn't even know it had happened before this. That's going to help to put political pressure on Algeria to do whatever, either apologize, take steps, or just not do it again,
I have to say, before this came out, I'd been haunting my Malian colleague to say, I know that the court doesn't have jurisdiction just like this, so what is the UN treaty they're basing it on? And having him call the Malian government to figure out what is the basis for jurisdiction. But in our chat, he said the reason why this is such a big thing and why the drone thing is so big is that Algeria is apparently trying to kind of increase its influence over that part of the Sahara Desert. And so that is stoking up regional tensions. And that's why this relatively small incident becomes such a huge thing and gets used for political gain. That was his explanation. So
I understand this idea of political gain, but isn't there also, Juliette, this sense that smaller states want to get kind of international law on their own side in some form, and they want to air their grievances in an international law forum, not just in a political forum? I mean, it might be quite quixotic. That was the way that I put it, because I was thinking also about Sudan taking the United Arab Emirates to court under the Genocide Convention, and, it looked like that was not going to work out, and it didn't work out. But it's still a matter of saying, hey, this is really bad and international law should be better than this. Isn't that part of it?
Yeah, absolutely. International law is the way that states talk to each other, and it's the rules that they are meant to apply and uphold. And so if certain states are not doing that, what options do small states have? It's not like they can go around throwing their political weight around. They can't use military force or anything else like that. So law is the tool that they have access to. And it doesn't mean that the problem is immediately solved, but it puts a thumb on the political pressure scale, right? Like when you're being publicly called out for breaking the laws that you have said that you want to uphold, that causes serious reputational damage, not just at the international level, but also potentially for the respondent state's domestic audience as well, their government. being publicly shamed for breaching international law, that's not necessarily going to make them popular at home either. So it's a tool that small states do use. And actually, like, shout out to Professor Douglas Guilfoyle, who is a co-host of mine on our other pod, and I believe a friend of this pod as well. And he's got a great paper in the British Yearbook on this topic about small states using lawfare as a way of gaining a little bit more political power. So yeah, international law, I think, is really seen as a tool to draw attention to these issues that might otherwise go very unnoticed, and also to put pressure on larger states to comply, back off, whatever it might be.
Now, we talked about before that a lot of these cases just get added to the dock and then languish there for many years and are forgotten. One thing that isn't very much forgotten are the genocide cases, or especially the South Africa-Israel genocide case. I think I get asked about once a week when something is going to happen in that case, and I always have to explain that this is just how long it takes, and there's no significant delay in this. For some people seem to think that, or haven't read all my other ICJ stories and just know how long this takes. So let's tackle some of those genocide cases that are making the ICJ also kind of famous and got everybody up and paying attention. First up, of course, we have South Africa versus Israel. The latest in that is that Brazil has invoked Article 63 of the ICJ statute and wants to intervene in the case. That makes over a dozen. I will not all name them, but interesting runners and riders include, of course, Palestine as an observer state to the UN. It can do things. Spain. We have Ireland, who also announced, and a clutch of South American states, and also Libya, which is going to be interesting. And I know that Janet has a burning question about interventions, so I'm going to let her take over.
I don't know what they are. I know that they're under Article 62 and 63. I can see this whole long list. And some of them are under Article 62 and Article 63. And I'm thinking, what is this, Juliette? What are these guys doing? I mean, what point are they making here?
It's gotten a little confusing. So if I can throw us back to the Gambia-Myanmar case, actually, as a way of starting this conversation off. So that's also a genocide case. And we've also got a bunch of interveners in that case. I think it's like 11-ish at this point. So they've all used Article 63. So I'll explain what that is. Basically, Article 63 means you're a party to the Genocide Convention. I'm a party to the Genocide Convention. Because you're talking about how the Genocide Convention ought to be interpreted or applied, I'd like to give my 2 cents, basically, on that question of interpretation. I can't talk about application. I can't talk about the merits. But if you're explaining, for example, what constitutes genocide under Article 2, I'd like to contribute to that discussion on what I think that article should mean. So that's what we've seen in that case, and that's what we also saw with the flood of interventions in the Ukraine-Russia genocide case as well. So that's one part of it. The other part of it is, of course, as we also saw with the Ukraine case, not just that states actually have something to say about the interpretation of the treaty, but rather that they want to be seen to be standing alongside the party that they view as the righteous party in this instance. It's a way of gathering your allies and, making known the political opprobrium that is, kind of the thing. It's kind of like a popularity contest, if I'm being honest, right? So it's being used as this mechanism. Now, why is it being used like that? Because it's basically automatic. The court will look at the declaration that's issued by the Article 63 intervening state, make sure that they are in fact a party to the treaty, that there's nothing else too dodgy going on. Otherwise, they're just like, yep, come and be an intervener, no problems. That's the way that part of the statute works. Article 62 is a little different. What Article 62 requires is that you have some kind of legal interest in the case. And so we would normally see this article being used in boundary disputes, where you've got maybe a tri-point where there's potentially going to be a little bit of overlap, and the intervening state just pops up to say, look, my claim sits there, and even though the court isn't deciding on that claim, we're just bringing it to your attention so that you can, work around it, or, as the court often will, just make the boundary point a bit short of wherever that claim is and leave the rest untouched. So that's really how that mechanism would ordinarily sort of work. There are two kinds of Article 62 intervention, which makes it even more confusing. One is non-party, which is basically just you say, this is my legal interest. I have nothing else to say, just wanted you to know. Party interveners, of course, get full party status. They can go all out. They can argue the merits. They can potentially make claims. Why do I say potentially? Because this has never happened before, right? We don't actually know the full boundaries of what that kind of intervention might look like. The court made it up in a case in the early 90s. They said, we think these two things can exist. It's never happened since. No one's been admitted as a party intervener. We've got no idea. So there's two states in the South Africa-Israel case who are using Article 62. One of those is Palestine. Their legal interest is fairly self-explanatory. The other one is Belize. And their legal interest might seem a little bit more obscure, but the basic premise of the argument is this. South Africa only has a right to bring this case because of something we call erga omnes, or erga omnes partes to be correct, because it's a treaty. That means the obligations in the Genocide Convention are owed by every state party to every other state party. So it doesn't matter that the genocide is occurring on the other side of the world. All states have an interest in pursuing legal avenues to prevent it. Now, so Belize's argument is basically, well, if South Africa can bring the case, I've got exactly the same legal interest, and so I should be able to intervene using Article 62. This is, again, completely untested, and we're going to wait and see what the court has to say about it. Procedure nerds are very excited about this.
I suppose my follow-up, Juliette, is this all going to slow down proceedings? Is this what you see? I mean, maybe you can make the comparison also with Myanmar, Gambia, because we don't need to go into a huge amount of detail there, but it looks to me like that's also being slowed down by all these interventions. But, correct me if I'm wrong.
No, you're not wrong at all. So what we saw in the Ukraine case, which was the first time we had this flood of interventions, was that the court went, oh my God, and made a few adjustments to its rules of procedure to accommodate these mass interventions going forward. So whereas previously states usually would have an argument about the admitting the interveners, you would also have the interveners all have a right of appearance before the court when it got to the issue, whatever it might be. They've made some adjustments to basically reduce the impact of these mass interventions. So now what they are doing is they are usually deciding the admissibility question on the papers. There's no kind of hearing. So they did that in Ukraine. They've done that in Myanmar as well. They've limited the amount of time that interveners can speak when it comes to the oral proceedings phase of the case. So they've made some changes, but it still does slow things down because even though they're making it the papers, they've still got to make a decision. They've still got to write that order up. They've still got to think about it, at least for a little while. So it does contribute to a slowing down of proceedings. But these Article 62 ones, that's even more serious. Now, look, no one is suggesting Palestine ought not to be intervening in this case using Article 62. But the other states, they're going to have a full hearing, potentially, about whether or not these states meet the threshold for a legal interest under Article 62. That's going to slow things down massively. And so it's really interesting to think about what machinations might be going on in the background here. So Nicaragua was the first one to actually apply using Article 62 in the Israeli genocide case. They applied to intervene as a party. That was really astonishing to everybody. They've since withdrawn that application, and Belize's is still sitting there. But as you pointed out, they've applied under both Article 62 and Article 63. So it may be that they're just kind of okay, don't worry about the Article 62 bit. We'll just go in with Article 63. It's all very up in the air, but it very much does slow things down. And in a context where, as you pointed out earlier, people are already asking, why is it taking so long? You have to sort of ask the question, look, what real legal value are these interventions adding to South Africa's case? Are they bringing new evidence? Are they making different arguments? Or are they simply standing in political solidarity? In which case, maybe there are better avenues or better venues for that kind of activity.
A couple of things come up when you talk about this. So one of the things is I always get asked, when will they rule? And my kind of standard answer is, I think Israel has to give its part of its memorandum in January next year. And then, if everybody goes really swimmingly, maybe we'll have hearings in 6 months. But I expect there to be preliminary objections. So not before the end of next year, at least. But with these interventions, it could go even longer, do you think? If you had to bet money, would you say 2026 or 2027 for hearings on the merits?
Yeah, 2027. Yeah, and it's not good news, right? And on the one hand, for people who want the court to be contributing in some way to the resolution of the issue, 2027 is a very, very long way away. But it's not an unusual timeline. The Gambia-Myanmar case was started in November 2019, and we still haven't had a merits resolution in that case either. So, I think when cases get kicked off with provisional measures applications, which means the court drops everything, it has a quick hearing, it issues these provisional sort of orders, the purpose of which is basically to preserve the status quo until it gets to the merits. It can look like the court's a great avenue for really quick action. You get 2 weeks, you get this order made, and the order is binding, and states need to follow it. And if states do follow it, it can look like really rapid response. But realistically, that's not what courts are there for. Courts are there to resolve disputes, usually after the fact, or to resolve disputes that aren't super urgent or whatever it might be. They're not rapid response units to deal with crises. So it might be bad news to the average listener, but the court is actually perfectly on time when it comes to the South Africa-Israel case. It's a slow institution. It's not moving any more slowly than in any other case.
And another thing that I was wondering is, if you have all these kind of interventions for solidarity, does that sway the court in a way? Is that used by the court in decisions to say this is now the consensus in international law because we had X amount of interveners saying that? Yeah,
that's a really interesting question. It does and it doesn't, and I think it depends on what the question is. So if you had, the Genocide Convention is a difficult one because it has so many states parties, right? So even these large interventions don't necessarily constitute a majority of the parties. But if you had, say, a majority of the parties to a particular treaty coming before the court and saying, we all agree that the interpretation is X, then it's pretty difficult for the court to adopt a different interpretation or to justify that, because the states are, at the end of the day, the creators of international law. They are the masters of their treaties. And so it does make it difficult for the court to say, no, we've read it and we read it differently if they're all saying the same thing. So it can add value in that sense by presenting this unanimous sort of front and saying, no, we definitely agree that this is the interpretation. But on the other hand, I think we did see a little bit with the Ukraine one, the court maybe being slightly irritated by having to listen to the same thing over and over and over again, and perhaps taking the view that, look, we don't need to have this in oral proceedings at the very least. You can all say the same thing in your written submissions, and that's fine, and we will take that into account. The one thing it doesn't do, and I think sometimes when I say it's political theatre, people get their backs up a bit and get confused about what I mean by that, maybe because I'm not saying that it's going to sway the court because they're like, oh, there's so many people in front of me, I'm going to succumb to peer pressure. The court is never going to do that. The court hears arguments from all states all around the world, the most powerful and the least powerful. And the point of the court is that it treats them all as equals and hears them on their merits. So it doesn't matter how many states are making a particular point. The court's not going to be swayed just by numbers in that sort of more political sense, if that makes sense. It's really more about, I think, domestic political consumption or theatres that get used in other, gets rolled over into other contexts. It makes it very clear to the audience that's watching at home that the majority stand on the side of Ukraine, for example, in this dispute. So it's not putting pressure on the court in that sense. But as I said, if the interpretation is all very much, this word means this in this context, the court's not necessarily going to ignore that.
I have another question about influence, which is a little bit more left field. And it comes a bit out of Steph's reporting recently in her Reuters role about sanctions on one of the other courts in The Hague, the International Criminal Court, because what we've also seen, those sanctions are coming out from Washington, from the Trump administration, and they have a particular problem with what they describe as lawfare, because they've been putting restrictions on some of the Palestinian organizations that collect evidence. They've put visa restrictions on what would be seen as state officials, the Palestine Authority and PLO. And now you've got the United Nations Special Rapporteur, Francesca Albanese, being sanctioned. All the individual members of the UN Commission of Inquiry on Palestine have resigned, not necessarily because they're being sanctioned. Maybe they plan to resign anyway, but that's happening. And I'm wondering, would the judges start to be concerned about this? UN judges, the ICJ could become the focus of the ire of the Trump administration, because they've got a decision that they're about to come up with at some point, I suppose, about Israel's obligations in relation to the United Nations, and I suppose particularly UNRWA, the United Nations Work and Relief Agency that works for Palestinians in the occupied Palestinian territory. So what do you think about all of that? That very long question from Janet, sort of telling you what's going on in my brain at the moment.
Yeah, it's really interesting the way that this has escalated, I think, recently, the anti sort of court rhetoric in general. Yeah, we've seen officials from the ICC get sanctioned. That's happened before as well, under the previous Trump administration. Would this ever happen to the ICJ judges? The problem with the Trump administration is never say never, right? Like you don't know what they're going to try. I would have, 10 years ago said, no one would ever do that. Don't be ridiculous. But now we just genuinely don't know. What that would do to the court is, so if the individual judges were to be sanctioned, that would make things very financially difficult. If the court was to be sanctioned, that would again make things very financially difficult because, of course, most people's email systems and banks and other things that you just use in day-to-day life run via the United States or involve United States companies. And so it can make just doing your job incredibly challenging. But I would also say, this is not the first time that the US has been annoyed with the International Court of Justice. They lost their preliminary objections in the Nicaragua case in the 80s, and then they just stormed off and refused to appear at the merits phase and didn't engage in the proceedings any further. The United States has not got a long history necessarily of engaging in cases where it thinks it's going to be unsuccessful. It's not that it's never engaged with the court. In fact, it's had many, many cases, but it doesn't like to lose, basically. Who does? But this is new territory, I would say, the idea that the ICJ could be sanctioned. And for a case that's not even directly involving the United States, it involves Israel, which is a completely different country.
I did have somebody suggest to me that maybe if there are rumors of looking to sanction the ICJ, it's just because they don't know the difference between the ICJ and the ICC, and they would mistakenly sanction the wrong court, which, as we know, is a classic mistake that lots of mostly photo editors make, but that we still get a lot, that people don't know which court is which.
This is true. Remember, if it has trapezoid windows, it's the ICC, it's the criminal court, right? That's your tell.
We had put down a couple of questions about Gambia, Myanmar, but I think you'd already mentioned, Juliette, that the proceedings had started, 6 years ago, coming up. I'll ask both of you, just in Gambia, Myanmar, what are your expectations on dates and timing? What are you hearing?
I always say that I kind of expect them to announce hearings on the merits any day now. I think it's going to be very interesting because this is, of course, the dry run for the Israel-South Africa genocide case. So I think the arguments in Myanmar, which the way that this case unfolded, the fact that Gambia could bring this case against Myanmar while they're not directly involved, is the direct reason why South Africa could bring this Israel case. So I think it's going to be interesting, at least for us, following the ICJ, where you can kind of track the arguments that they're going to make and track how that's going to potentially play in the South Africa case. So even if attention on Myanmar is kind of dropped because Gaza and Ukraine are sucking all the air out of the room of the media, I think this is going to be one that everybody's going to talk about again, because we know how it's going to kind of pave the way or influence how this other case is going to go, because the ICJ does love its own precedents, especially when they're so close together in a way.
Absolutely. I think it's going to be really interesting in a couple of, I mean, for starters, I mean, of course, it'll be fantastic for the Rohingya people to, finally have a resolution to this dispute. I mean, I think that will be really meaningful. And I'm with you on the date, on the timeline, because the last pleadings were filed at the end of 2024, end of last year, and then the last round of interventions, the order admitting them was July. So it really is like any day now they could be announcing hearings. So what's going to happen? Well, there's a few issues. One is, the question of what constitutes a genocide. What is the definition of genocide? We've seen in the court's previous case law that the definition is it's very difficult to pass the hurdle of it being genocide, right? So that's one of the first questions that people are going to be looking at. How does the court deal with this question of intent? Does it change the standard or adjust the standard at all in this Gambia case? How does it apply it? That's going to be really interesting, because the court will, I guarantee, use that going forward into the South Africa-Israel case. And then the other really interesting thing, I think, is the way that the court's going to use evidence, because we've seen here that the fact-finding missions in Myanmar have been really useful to the court as evidence of what is actually happening on the ground. And we've seen in the South Africa-Israel case again that the court seems to prefer, where possible, to rely on UN-based reports. I think it views those as fairly authoritative and independent. Of course, the parties will have their evidence that they will also present, and the court will take that into account. But it's, the UN doesn't have any, or these fact-finding bodies don't have any formal role as like an official expert or anything along those lines that listeners might be familiar with. But I can't help but get the sense that the court almost views them a little bit as like a third-party expert resource that they can use for fact-finding in these very contentious, difficult cases where getting on the ground and getting evidence is incredibly hard. So I think those two things would be the things I'm looking out for. What's the definition of genocide? Has it been met in this case? Which would be very significant for the people involved, and then how the court uses evidence.
Interrupting our regular programming just to say, please come and support us on Patreon and get our newsletter. For the price of just a cup of coffee, you can hear Janet and me talk even more about war crimes and books that we like to read and music that we like to read and what we are doing. Come and follow us and support the show. Thank you.
Juliette, thanks so much for making time in your busy beautification schedule and teaching as well, I'm sure, in terms of your real life. We have a couple of questions that we ask at the end, and Steph is trying out a new one, which is there a job that you have done any time in the past that you would like to tell our listeners about? I suppose it's partly about the fact that we often have very different career paths. So it could be an accident that brought you into this field, or it could be that, it's just something strange that you used to do.
So this is a great opportunity to talk about the shoe store in Cambridge, because when I first arrived in Cambridge, I had plans to work as a lawyer. It was, I had practiced as a litigating lawyer for a few years in Australia. That was my goal. And it was in the days when people were like, yeah, no worries, it's easy to, come over and get a job as an Australian lawyer. I couldn't get a job. It was not happening. And I couldn't pay my bills. So I literally door knocked a bunch of shops in Cambridge and was like, I need a job. And I got a job in this little shoe store, and they sold Echo shoes. I don't know if anyone uses them, but they're a good shoe. I would still genuinely recommend them. I will sell them to you over the podcast. And it felt like this huge kind of failure on my part, right? Obviously all my dreams were shattering before my eyes and it wasn't happening. Turned out it was the break I needed, right? Because I was kind of burnt out from years in litigation. I was going into the same job because that's the job I'd always done, and I didn't necessarily want to be a commercial litigation lawyer. It's just that's what I knew how to do. And over the course of that year, I sold a bunch of shoes. I got to know some really great co-workers who were often doing really interesting things. Like one of them was an archaeologist, really cool people, and just be a townie for a year as well, which was also cool. And then after the sort of 12 months-ish was up, I had a chance conversation with a friend in a pub, and she said, look, why don't you just send an email to the Lauderpack Centre for International Law and just say, look, happy to just do a bit of research, whatever, for free, basically, intern, because, I'm feel like I'm losing my touch a bit and I just want to keep my skills up. I got a response to that email really rapidly from none other than James Crawford, who said, we've got this case which has gone a bit sideways. We have 2 weeks to file this pleading, and can you help? And I was like, well, I was a litigator. Yeah, I can actually help. I know how to file a pleading. I've got no idea about bilateral investment treaties, but I can write a pleading for you, no problem. And so it was a really steep learning curve, 2 weeks of absolutely crazy hours. And after that, James was like, cool. We get along really well. We like talk about cricket. We're from the same place. Do you want a job? And I was like, yeah, I do. Thanks. And that was kind of that. So I think, if it hadn't been for that little break in the shoe store, none of that would have happened. And I never would have ended up working for James, which I did for nearly 2 years. And they were like the best 2 years ever. And I miss him so dearly. And, I wouldn't be here doing international law. It just never would have happened. So don't think of career. My advice would be, my takeaway is, don't think of career breaks as endings, right? Like they can end up leading to just the best sort of stuff. It's not, your career is not a set of train tracks. You don't get on and then just get off at the end. You can go down all kinds of funny little pathways. That's my shoe store story.
Hooray for sensible shoes and and job breaks. When we were so discussing this new question that we wanted to try out, that we forgot to ask the overall question of, is there anything in the ICJ chat talk that we had that we didn't touch upon regarding the ICJ, but you do want to highlight?
Oh, I guess just like the court is so busy. I think it's just kind of, I don't have much to say about it, but it's just really worthy of note. The court has literally never been this busy before. There are so many cases on its books, and more just keep coming, and I think back in the sort of 1970s, 80s, when the court had almost nothing going on, no one was using it. People were talking about, is this institution ever going to be relevant? No one would ever have predicted this. And then even with the really political cases that get a lot of attention and potentially create a lot of dissatisfaction because people say, why isn't the court doing more? Get on with it. The court's losing legitimacy. I'm just pointing to that list and going, no, it isn't. States are seeing usages for the court, be that provisional measures, be that political messaging, ultimately also be that resolving, disputes that they have. The court is booked and busy, and so it's not going anywhere. Yeah, that's probably the one other thing I just wanted to point out.
Sorry, Steph, I failed on that one. I will ask the final question as needed, and I will reserve the right, if I may, Juliette, to pull you back onto the podcast in a while for me to ask you all the cookie questions that I have about could the court get involved in this or this or this when we, maybe after the Myanmar-Gambia merits things, because I'm sure we'll be very busy covering the court, because I still think this court has an awful lot of other things it could and should be doing, and I'm pretty sure states, like you have already pointed out, are going to carry on using it. But our final question always is there something that's in your Netflix or whatever streamer you use queue that you'd like to recommend to people, or a book that you've been reading recently, or a podcast? Well, I don't think you even said the name of your own podcast, which is called To the Bar, which we both listen to regularly and really enjoy very, very much, and much appreciate these international law professors giving us the benefits of their thought. I'm very pleased that you drift into my ear holes every couple of weeks. But what else would you like to recommend?
Oh, wonderful. So yes, besides our pod, okay, if you really genuinely want to, switch off and just do something that will be fun and probably make you cry. For those who are listeners to Call to the Bar, they will know that I do enjoy a good K-drama. And I'm a couple of episodes into a new one called Bon Appetit, Your Majesty. Basically involves a time-traveling Michelin chef who goes back to the Joseon dynasty and, I'm presuming falls in love with the king. I haven't gotten up to that part yet, but that's a fairly traditional storyline for these kinds of things. It's funny, it's entertaining. There's some amazing cooking scenes that will, don't watch this show hungry, but I would, the lead actress, is just adorable. So I would thoroughly recommend that. It's on Netflix, easily accessible. So yes, if you're looking to switch off, it's a good one.
Great. Thank you so much, Juliette. Time-traveling chef sounds exactly what I need. I'm sure, Steph's nodding as well. So thank you so much for making the time and for your recommendations.
No worries at all. Always great to chat.
This was Asymmetrical Haircuts, your international justice podcast. Created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.